Sure. As usual, waiting on Roxy.
All right, now you're ready. Good morning, everybody. Are we live? Yeah. Good morning, everybody. I'll just do a short update of where we are. Can you fix the Thank you. And I just utilized, just this little, it's a very simple PowerPoint presentation, but just to utilize where we are, progress we've made, what to expect, things like that. Nothing crazy. So if I can get into it. So prior dates, we've already had 2 sessions on January 31st and February 9th. We have upcoming dates on today's session 3, because we're doing 2/16, and then our proposed sessions 4, 5, and 6 are scheduled for 2/21, 2/28, and March 1st. Also, with regard to today, on today's our 3rd session, 2/16/24, and I've actually given you a clean copy of the ground rules. I know we signed them redlined. We went through them because of formatting issues. We were unable to do that on Friday. We have a clean copy. Feel free to read through them and make sure there aren't any. I went through it to make sure there weren't any typos, but a 3rd and 4th, 5th set of eyes is always good. But those should be correct. And I just wanted to point out with our session today, we've agreed that this is the cutoff for the articles and sections that we're going to be discussing at the table. Now, that is not to say, the understanding in our rules is not to say that we have to have all our proposals here today, but that we have identified and placed the items or told each other about the items that we will be discussing and that we believe on each side are subject of the impact bargaining. Okay. Last session, again, we had an agreement on the ground rules, and we had an agreement on the definition of uniform staff. Again, we've given you some executed clean copy, and just as a reminder, we've already went a reminder on today's session, which is that we identify all the topics that we're going to be discussing. Second, just to reiterate that pursuant to the ground rules, we deal with the bargaining representatives here on issues for the impact bargaining for this limited session. That is to say that the city's not going to be lobbying the union members or anything like that, and that the union at the same time will not be talking to city council members or our managers that we represent on the bargaining issues. We did make a huge progress on the agreement on the definition of uniform staff. That was imperative to provide the stepping stone for all of the other issues that are subject to bargaining. So we have a tentative agreement for Article 2, Section 14, which is the definition of uniform staff. We will work on getting that tentative agreement. There's another item on Article 2 that we will be proposing today. And so what we anticipated doing was getting that part resolved. And then that way we can do a tentative agreement for the entirety of changes that would be on a physical copy for the entirety of the agreements that would be made on Article 2. Today, the city will be providing these proposals for today. It'll be Article 1 regarding the date of the agreement, Article 2, number 1, the definition of agreement, Article 5, Section 1, Article 8, special leave, and Article 10, term of agreement. We anticipate today, in discussions leading up to this session, we anticipate that the union will be providing a proposal on Article 13, the hiring processes. And we also anticipate a union presentation on a new article. And just as, I just want to go over what we view today's session looking like. I think a lot of the work, we're going to do all our presentations and proposals this morning. The city's going to present, and then we'll hand it over to the union. And we anticipating going to caucus. The proposals that the city is placing on the table this morning are fairly simple and have a lot to do with just the logistics, how the amendment is going to be made, how we refer to the amendments, how we refer to the actual agreement. Items such as that, they're pretty simple, and I think they're going to be very agreeable. So I think that that's something that we could work out today, and I hope to have a tentative agreement. The articles that the union we anticipate is proposing have a lot more substantive issues and factors that we really have to dig into and make sure we all understand, and have the ability to ask questions and respond, et cetera. So what we anticipate is that we have our first session, we caucus, go back, and then possibly soon thereafter, at least address the simple articles, to see if we can come up to a tentative agreement. And then once we do that, deal with the simple articles, we will continue working on the anticipated proposal for 13 and looking at the new taking into consideration any presentations that the union has today. So we envision this first session being probably the biggest session, a second session dealing with hopefully TAs for the simple articles, and then caucusing the rest of the day to really work on the Article 13, which is going to be the hiring, and then looking at how that impacts the rest of the issues that we have all identified. Bridget.
And if I could build upon that just a little bit, what we envision doing and kind of moving into the next bargaining session is taking 13 and then making sure that it coordinates in with 12. So that by the next time we can be kind of working on the two jointly. And if we have any, I don't think there's any conflict between the two articles, but we just want to make sure they integrate correctly. So we kind of see taking those all as one chunk. Love the fact that you have 13 that we can now take and dig into and see if we're on the same page. And we've had a glance at it, and I don't think we're going to have issues, quite frankly. Generally, conceptually, maybe structurally a little bit, but I think it's just the article structure, not the departmental structure. So I think we just need some time to work on that, and then moving forward, try to even spend some of the time today looking at how that interplays with 12. So I think kind of the purpose of laying out the day like that is so that if you have people who are watching, they'll know, well, we'll come back again. But you know, for the afternoon, we probably won't have a late day session, at least how we envision it right now.
Yeah, that's right. And we have a lot of caucusing to do about Article 12, I think also, and then to dig into, we haven't had a time at the team to talk about your presentation items.
Okay. So if we're on that same page, I think we'll just go into we'll present what we had previously sent you on the 125823, I think.
Yes, we're going to be presenting on Article 1, Article 2, Article 5, and Article 8 and Article 20. And we have previously, just to make these sessions productive, and so we are all on the same page on what to expect and what will be discussed, we did send you over the drafts of those articles, and they have not changed since. So there's no changes to what we have sent to you. The first proposal from the city today is on Article 1, the preamble. And we will correct this. It'll be the proposal will be made today on February 16th. This will be the date of agreement. We've noted in here, we're proposing to note that it's amended as of May 1st to 2024. And I just want to talk a little bit about that May 1st date. The May 1st date is just the date that we anticipate, or kind of a placeholder for the effective date of the amendments. And that is not a hard date. It's gonna be whatever we accomplish, if it's sooner, we can make it sooner, and it may possibly be later, but we're hoping that it's sooner, or if not, at least on May 1st. So that's where we anticipate a placeholder for the effectiveness of these amendments, on this limited reopener. So that May 1st date, whenever we use it in all our proposals, literally a placeholder. If there's any question on that, or we can have further discussions as we get near the end of our negotiations and finalizing, a tentative agreement on the amendments, we can really tailor that date and make sure that it fits with everything that we discussed and ultimately agree on. We propose adding a new paragraph. Leave the first paragraph the same because it doesn't change the term of the original agreement, but add the next paragraph that states the agreement is hereby amended by the city and association with the first effective date of May 1st, 2024, which is again the placeholder language, unless specific provisions or exhibit terms set forth a later effective date. That is to say that if there's another effective date, say on wages or, a pay period or something like that, that will be addressed specifically. As indicated within the specific articles and sections in this amended agreement between the City of Austin and the Austin EMS Association effective May 1st, 2024 through September 30th, 2027. And the way that we envision this amendment looking is that we have one document for the original agreement that was from the effective date of the original agreement up to the time that the amendments are made. And then once the amendments become effective, that would be an entirely separate document. That way, for ease of knowing what was changed, we can somehow figure out how to indicate that, whether it be a red line document in some way with some underlines, or, the logistics of that we can do at the very end. But we envision just one document for ease. That way people aren't having to go look at two different documents or find an addendum, or maybe a contract, maybe missing the addendum, but no, here it is, things like that. And that's really from experience on dealing with questions on the contract, grievances, things like that, that we know that we're dealing with one document. It's easy for everyone to look at and find the information. So that's what we envision. And that's why this was written in that particular way. Any questions?
I don't have any questions for any such disagreements, so, we would be as close to TAing, just knowing that the dates might change.
Right, but, and that is with the caveat, and we can even put a little asterisk on the bottom that May 1st, 2024 date is a placeholder, and we would determine the date.
I think that's good to get some stuff just off the table, just a little footnote with the thing like we've done before on the TA itself. Yeah, the state subject to. Great.
Okay. The next one is Article 2. We've already tentatively agreed to a really important definition of uniformed staff. The only other item here has to do with the definition of agreement, and that is to incorporate the amendments that we're working on during these sessions. So we propose adding to the end of the sentence, and may also be referred to herein as the amended agreement, and then put again amended as of May 1st, 2024 with that placeholder language to be determined later. We also have just a footnote on the definitions on the bottom that says all other definitions within this article shall remain unchanged, just so it's clear. Those are the only two that are affected. Any questions there?
No questions.
Okay. And again, we can also include, if we're able to TA this, we can also include the asterisk on the placeholder language.
I think for pretty much any of the articles that these are non-substantive changes, adding the little asterisks, some TAs.
Okay. Once I go through all of them, we can go over them and let me know if there's if we can just TA them as they are, or if you need to propose a different change of language. And at the same time, when we're caucusing, we can work on having them prepared for when we get back into the sessions later today. Okay. Article 5, which is the union dues checkoff. Seeing as how we have new uniform staff that are coming in that have never had their union dues deducted or payroll deductions. We're proposing to add a new section at the very end, which states for uniform staff members added under this amended agreement, such dues shall be deducted beginning with the first full payroll period after May 1st, 2024, and we'll add the asterisk on the placeholder language.
And also, no substantive issues, happy to TA on this, and just want to be clear that those new members would still have to physically sign the forms and everything in addition, and then it will be effective.
Right, that is absolutely correct, that all the other provisions were requirements in order for the payroll deductions or the dues, the union dues deduction to happen must happen, that they will still be subject to the rest of that article, which lays that out.
Okay.
So on Article 8, special leave, we propose on Section 3, under separation pay for sick leave hours, Section A, to add in the sentence at the end that states, this section shall also apply to uniform staff members added under this amended agreement. And that brings all those new people into this section.
We did have some questions about that, just kind of seeing what the intent was, because to specify that this section also applies, would that be, would that assume that other sections may not apply, like in that Article 8?
Yes,
like sick leave donation, other things along those
yes,
lines?
so within, what article is this?
This is 8.
Yeah, so within the, we do intend to separately bargain on changing the accrual rates to what the EMS currently has, and we had talked about PPL conversion in lieu of that. Also the accrual caps, so that those will, how that change might take place. So this is kind of its standalone. They currently don't get any payout at sick leave. We do intend to include them in that. So this part of it is off the table, so that's just this section. Whether, I quite frankly think that the other parts of it are in a different article. I think they're in Article 9 on the actual accrual rates.
But, for example, for emergency leave, the city of Austin personnel policies do have emergency leave for their folks. This isn't the same like paid. And they also have their own sick leave bank that applies to not all civilian staff. And so I think they're just curious if you all meant to exclude them from being able to access sick leave donation from staff.
Yes. So if you want to hold on this and make sure that we can re-review it, to make sure whether we need to address that or not, or if the fact that it's an automatic, then we can at least make a note of that so that it's clear. Yeah, because that concept does change once you become sworn and how they are able to do it in payroll, et cetera. So that's was there anything else specifically that you noted in that article that we need to take a look at?
Not in that article, and this was my concern about preemptively saying that we can't bring up other issues, because if y'all are saying that each section needs to specify whether or not it applies to these new folks, then we would really have to look at every single article. Like for example, Article 7, when we talk about court pay, for example. And so somebody comes in, they're sworn, they get subpoenaed, we would want court pay to apply to them. And our concern is that if y'all specify that this one specific section applies to those folks coming over, does court pay not apply to them? If somebody comes in as a captain or a commander or wherever they come in, do the OCP rules not apply to them? Those things.
Yeah, so to answer your question, we intend that they all apply. I think this one was just such a huge, we better make note that this is changing for these people, because this is a pretty big change, you know, that we don't want to leave out. The other ones, not that it doesn't matter that they get court paid or whatever, but everything else was shift over. But if you want us to hold this and take a look at it in conjunction with 7 and 9, we can do that. Conceptually, I'm sure you're happy that they're gonna
Yeah.
be able to get,
Yeah.
but if you want us to hold that, to go with some others, we can do that.
And just so I understand your concern on the proposed language, is that what you're saying is that this may imply that only this section will apply to the new uniform staff members and maybe be by implication an exclusion of the things that we actually
Yeah,
intend
Exactly.
yeah,
to be
because this
covered.
is
Okay.
specifically.
Yeah, and so in our Article 26, we had intended to do a catch-all on other ones. However, on the donation bank, I think it is important that we address that one specifically. Because the court pay and all of that, we're gonna do anything not here specified that is already been, one of those for the basics, right? But this one we thought needed to be called out. I don't disagree with you though, specifically because there's always been a question, well, why can't we do the donation the same way? And so that does need to be addressed.
And I just have one more and then I'll, but because we do, specify and I think it's in Article 1 or 2, like that all things apply and then we unless specifically excluded, later in the contract, just how we exclude 16 and 19 probationary. Because this language specifying that this applies, my concern is not with this group of folks, but later, people not, that didn't negotiate this, that there could be a misunderstanding of just what else doesn't apply if this section does specifically apply.
Understood.
We'll go back and look at this. I know that one of the considerations that we made in proposing this language was the language that states that there has to be 12 years of actual service. And so I think that was one of the considerations that we had in saying, well, this also includes the people that are coming in. So let's take it back. We'll talk about it. We'll discuss any additional items such as the donation leave because we
Yeah,
need to
that's-
make sure that we're not excluding, but I remember that was the consideration was, we're having these people move from ACMO to EMS. They haven't been, they will be dropped literally into EMS. And so we want to make sure that the benefits that we intend them to have, they're not excluded from by some technicality that we didn't consider.
Yeah, and I think we were hoping to address that in defining how we quantify their years of service. And so we, kind of grandfather them a certain number of years of service. Then we were hoping that that would be kind of caught in these.
And that brings
And I think we've gone through like line by line of the contract and tried to address it each time. Is it service with the department or service with the city? And I'm not sure that our answer was always the same in each consideration. So I think we kind of, and on this one, as Roxy said, it is kind of intended to go back to the 12 years. I think you'll find that most of the people moving over, I think there might be one that's past 12 years. So it's not a huge, but they get credit in the meantime. And so, yeah, we'll take a look at that again with that in mind, because it's a good point. Yeah, and I don't want any implications that, well, we said it here, so do we have to say it in each place, even though we have a catch-all? I think it was because this was oddly, yeah,
Okay.
yeah, so we'll
Yeah, we'll
discuss
look at
for
it.
sure.
There's, I think that the important part is that we discuss the intention and the goal that we're trying to accomplish. And that's why we're here to wordsmith, so that we can make sure that we both agree on the intended goal and there's not any unintended consequences of that. So that's why these discussions are important. So I think we're all on the same page with what we want to accomplish, and we completely understand your concerns. And it brings to light how, even though it may seem simple, it brings to light how complicated this is going to be, because one sentence may impact, something else that we're, like the promotions or the hiring or the years of service that we've identified that we need to discuss at the table.
Well, and while we're on this one, we might as well just ask the question on your intent. The reason, so 12 years of actual service has always been interpreted, although it doesn't say so, with the departments. So although it didn't say so, we thought we needed to say, these people are included here. But, you know, that's one of those, is it city, is it whatever? So our intent on this is that the people coming in also have to have at least 12 years of actual service, but that it's with the city, so that they don't get penalized because the departments are being merged, but that the 12 years still stands. So if that's and I don't know if you know what your consensus would be, but that's our point there, so we can.
Yeah, I think our thought was that we would kind of address the years of service question in the catch-all in 26. And so then define, you know, as long as they are the staff that are moved over, then their years of service in Montco count or whatever towards department.
And we could look at all of our individual ones and see if, like I said, I don't know that they're all the same, but they might be all the same.
Sure.
We might have done them all with the city. Yeah, thinking about it. So maybe that is a better way.
I think a concern and maybe just a suggestion is that because in our definition of uniform staff, that we specifically say that it excludes, you know, whoever, and also any other employees exempted by terms of this agreement. When we start, because that more refers to excluding people specifically in the contract as opposed to including people specifically in the contract. And so that I think was where my concern of if this section applies, does the other section apply, as opposed to saying, like in 16 and 19, this does not apply to probationary. To make some of those things, you know, we just come up, because I think we have the same intent. It's just coming up with the right wording where it doesn't confuse a later team or an arbitrator if that in the instance of like grievance.
You know, those are all good points. Let us brainstorm over those a bit and make sure we're all of the same opinion before we
Yeah.
propose back.
And the
Maybe
only
we're
thing
not
I I think has been brought up during this discussion is that we're going to have this catch-all article at the very end, right? And I'm gonna try my best to keep up, because there's gonna be keep up a running list, but I think we can note that the catch-all article is gonna have to be conceptual. We're gonna have to keep bullet points of what to include in there as we go through these articles. And then at the very end, we can kind of fine tune that as well. So I have, so far in the catch-all, that one of the items that we may need to address is whether the years of service for these new uniform staff that are coming in, does that mean equal? They get credit for the time they have with the city, not just with the EMS. So, that's the first bullet.
We have quite a few.
Yeah.
Oh, we do
I-
too.
we do.
It's not from today.
Okay, so we will go back on that one and we'll continue discussing that. Let's see. The next article, and the final article I have this morning is the Article 23, the term of the agreement. Again, this goes in line with Article 1, which was the agreement, Article 2, Section 1, which is a definition of agreement. And here we propose to just show, oh yeah. Here we propose to again show that the term of the agreement amend is that as of the placeholder language May 1st. We added this new section B that states the amendments to this agreement are effective May 1st, 2024, unless specific provisions of the exhibit terms set forth a later effective date.
That of the definition to
Say that again?
the of exhibit should be for exhibit.
Oh, okay.
terms,
Oh, that's right.
Just to match up with the language.
Yes, that's correct. Typo. Specific provisions or exhibit terms set forth a later effective date. Yes. So that mirrors that first, or that definition that was in section, Article 2, Section 1. And again, we'll add the footnote of the placeholder language for the May 1st, 2024 date. The proposed to add a second sentence to the next term. The original language states that provisions of this agreement do not apply to any employee who separates from city employment before the effective date of this agreement or before the effective date of any specific provisions hereof. We propose to add, likewise, the amendments to this agreement do not apply to any employee who separates from city employment before the effective date of any amendment. And this is another proposed section D that we propose to add. The amendments made to this agreement do not affect the agreement between October 1st, 2023 and the effective date of the amendment. And that's just clarifying language to say that the agreement was one way before our placeholder May 1st, and then after May 1st, there's some changes.
Well, and let me just jump in right there. The specific intent of thinking we needed to write that down was because in Article 26, we intend to carry over well, we're not gonna agree X, Y, and Z. But there are other provisions of that agreement besides just those that were impacted by the reopener that were still in effect, that you do still have the right to grieve, so we wanted to make it clear that those are the terms. Not that this would change that, but just super clear, there's still, that exists still, so.
Yeah. I don't think we have any questions or disagreements. I'm happy to take this.
Okay, yeah, those were the only changes. So, from the articles proposed, I'm just confirming that we can prepare a TA on Article 1, the preamble, Article 2 definitions, Article 5, the union dues checkoff, and Article 23, term of agreement. And then we'll leave Article 8 is still up for decision. I think that was all I had to present on this end. So I think, do we have any other items? I think that's all that we have right now. And so we'll turn it over to you.
And you'll put up 13 forms.
Just gonna ask for you.
And I think kind of like what happened with Article 8 is that, I almost hesitate to send these articles over as a formal offer because there are just so many things that I think are helpful to discuss at the table. We're happy to do that as a starting point. But, we're not, in a lot of ways, we really are excited to collaborate with the city on what this looks like. And so, just a point for us to start discussion on both Article 13 and 17. Let us get the real work started. So we did not have changes in Part A or B. We started in Part C. So with the understanding, and I'd love for y'all to elaborate more, but we had originally conceptualized having the paramedic practitioner in the field, but we recognize that can muddy the way that promotions look, and there wouldn't be one stream. And if there are any other reasons, I would love to talk, and maybe we should just have that conversation about what the structure looks like, including the paramedic practitioners. So we put a placeholder in understanding that we would create a third branch, and still want to have that conversation with people, why that would be necessary, but understanding that that's the city's intent, we wanted to start somewhere. So that's why we have a clinical. It could, easily revert to field if that ended up being the case, but, so basically, all of this language, is just mirrored from other parts and made specific for paramedic practitioners. So we know that we don't currently have any people that are uniform staff that could be a paramedic practitioner, and we have the same issue for clinical specialists in the field. We don't have enough folks that are eligible to take the test and have elected to take the test, and so we allow for a direct hire. So we recognize that a direct hire would be necessary for the paramedic practitioner. in the same way that it's necessary for a clinical specialist. And all this specifies is that they have their paramedic and they have either their physician assistant or their nurse practitioner license. In the actual hiring, we know that previously the OCMO had more requirement that they had to be a PA for 2 years and so forth. But we also know that the department has additional requirements for the specialist direct hire as well, which is that they have to have a year of service in a 911 on a 911 service. And so this obviously doesn't preclude the chief from adding or the medical director from adding any additional hiring stipulations. But we just put the basics here. And so this is really less than what is required, but we recognize that the chief and the medical director have the ability to add on additional requirements. So that's all that is right there. And all we did is, since we added paramedic practitioner into the direct hire, we just included it in this language. The only real substantive thing that we added is, so for our direct hire clinical specialists, the city can only do that direct hire if there are not enough applicants or there is not an eligibility list for promotion. And so we wanted to mirror that same language for the direct hire paramedic practitioner. So basically, the department announces that there's a vacancy, and any applicants that are internal, because we hope that, when we show you our version of Article 12, it will include the city sending folks to PA school, that those folks will be hired before any external candidates. That's our attempt at doing that. So after an announcement that a vacancy exists, applicants who meet the selection criteria may be hired without being placed on an eligibility list if no uniform staff who meet the criteria submit a letter of interest. So, we do have somebody right now that just finished her nurse practitioner, I believe, and she obviously knows that there is a requirement for a few years practicing in the hospital. And, if she completes that, we hope that she is will be accepted before any external hires. So that's the intent of that language.
I think it just to put your mind at rest, conceptually, we're fairly close to being on, if there's tweaks or where things are put on that concept, we have the same general concept, so I think that's a good start.
Yeah, and I think that's the only change we added into 13.
We got one more done. Okay, great.
Oh, okay. So if somebody is hired in the direct hire, they would be at the base year of the paramedic practitioner and clinical. I don't even know if that's necessary, given that it's not a promotion. But we wanted to at least have a placeholder in case we thought it was necessary. We recognize that if somebody, and maybe it is just a good reminder of us to think about, if somebody does come from internal, we assume that they would get those years of service and drop into that step, right? So if I go between comm and field, I'm not gonna lose my seniority after I have 5 years. And so we kind of assume the same thing for paramedic practitioner. Obviously, we're open to discussion, but that's kind of the intent that we're trying to make, is that if you're a direct hire from external, then you can start at the base. I guess the implication, and I'm not sure if we need to specify it somewhere, that if you're an internal transfer into this division, that you would keep your years of service.
I think we should address that. Yeah, because that had not, I'm like writing that down, like, oh.
Yeah.
Not saying we agree or disagree, after
Sure,
that,
sure.
that was how do they drop it differently as far as step? Is that
Exactly.
different than seniority? Is that, how do those all play out? Okay.
No, I think this is probably, yeah.
So, I was.
Oh, I think that that is just, I think we copy and pasted it twice, so apologies that it's not, but there shouldn't be anything else, any other
Oh,
change.
okay.
Yeah.
Yeah, because it was identical
That,
language.
that had confused me.
Yeah, I'll send over.
Correct.
That's part of the
Wait,
strategy.
I'll send over a clean copy. I'm sorry for that.
Yeah, that's
I think we were just trying to get it over to you as quickly as possible.
I was already there before your strategy.
Yeah, and we are on board with the fact that so that we can make some progress, you're giving things that are in draft form and you have the right to change. This is not what you said, that we're not to the point where we are taking this as your final, yeah, official even. We need to at least try and
Start somewhere.
hopefully, yeah, maybe be able to work off from the same document and, you know, so that we can start somewhere, yes. But we understood that you sent it over as a draft with like, we're still thinking too, so.
And we feel pretty comfortable with this version, but definitely would love to, see.
Yeah, and I think we'll be a little more drafty as we incorporate 12.
Yes, absolutely.
But we don't want to not share thoughts and language in ways that we've been thinking through things either. 17.
I think you're really gonna like. I think there's a lot of context. I can start a little bit. I think there's a lot of context around 17, and this idea of putting, things like clinical review into the contract. And I hope that y'all recognize that we really, really respect the sensitivity of that and respect the ability for the medical director to de-credential and to modify folks' credentials. And so I think you'll see that our starting could have been much stronger. We could have laid out exactly how the appeals goes, exactly how the review goes, and we didn't do that. And furthermore, there's nothing in here that is content-wise different from what is in the clinical review process that's already in policy. The only thing that we feel very strongly about is just making sure that we have some representation and a little due process. And so you'll see that we don't lay out, they have to, for the first interview, it has to look like this, and it's much less prescriptive than Article 15 and Article 16. So I would personally like a lot of credit for that. You'll see Section 1 is, there's nothing substantive here. It just says that this article supersedes Chapter 143. You can go down to definitions. And I also think it would be helpful to understand what the process is. Have y'all seen what how the process looks in policy? I'll send it to y'all, or Chief Partner can give it to y'all. But it does, so basically the process is a DMO, and can you see, I think we have 5 articles, you should be able to pull up all 5 in the same screen.
Say that again.
There should be 5 articles, 5 definitions.
Oh, right here.
Pull it up. Yeah, great. So right now, what happens is, the medical director has different levels of things that could happen. So we could say an esophageal intubation. So when you're intubating somebody, you want it to go in the trachea. An esophageal intubation is what they call a type 1 review. And that means that the medical director needs to hear about it within a certain amount of time. And we didn't put in like that type of stuff in the article, that like these certain things need to be reviewed at this time, et cetera. But that sometimes those things, what will happen is if the department finds an esophageal intubation, the DMOs will go out and do an interview with the provider, an initial interview with the provider. And most of the time, that's as far as it goes. Sometimes the DMO, in consultation with the doctor, will decide, oh, maybe they need to refresh this CE or have this clinical improvement plan. And it rarely escalates to the point where the medical director or any of the staff believe that it might turn into revoking of the credential or reducing the credential. And so we're really focused on those specific incidents. We're not talking about, we don't believe or want any say about your normal clinical. It is the only times we're concerned about is if somebody is going to get their credential taken away, which is effectively removing them from the job. I mean, they can't work here if they don't have a credential. And we're talking about when the medical director chooses to take away or decrease their credential, because then we're talking about a loss of pay if they're demoted, if they get their PL6 stipend, for example. So those are the only instances that we're talking about, is if it will basically cause a separation or an indefinite suspension or a loss of pay. So the process is that the provider has an initial conversation with the DMO, and then sometimes it will go to what the DMOs call an in-person provider meeting. So that means that the DMO and one of the medical directors will have a further conversation about the call, and then the DMO and the medical directors will come up with a decision about what the plan is. And if they decide that it's going to result in or that it could result in a modification or credentialing, then there will be another meeting with the medical director. So this is established practice. We're not saying that this is what should be done. This is what is in policy and procedure, and in the agreement that we signed, or that the city signed with Dr. Scott. And if it results in a decredentialing or a modification, there is an appeals process that is also laid out in policy, and they call it the Medical Director Credential Conference. So none of these terms are our terms. These are all terms that come from the medical director, either in the COGS or in policies and procedures. So you can scroll down. So the only thing we're really asking for is that a uniformed staff member has an attorney and an association representative in the in-person provider meeting. So we're not even asking for representation with the initial interview with the DMO, which you could compare to the initial interview with the OPC. We're not asking for that. We're just saying that when they meet with one of the medical directors, that we're available, and that is also in the policy and procedures, that they can have a representative in that meeting. So there is the meeting with the medical director, and then if that team, the DMO and the medical director, decide that it will result or could result or should result in a decredentialing or modification, there's another meeting with the medical director, and we're asking for representation in that meeting as well. And in policies and procedures, it is also offered that a union representative can be in that meeting. So we're not adding anything that is not in policy and procedures already. We're just trying to enshrine those protections in the contract in the event that we have a future medical director that might feel differently. Okay, you can scroll down. We also recognize that the medical director has the right to modify or revoke our credentials. And so we also put that in the contract, that right now there is a clinical operating guideline. It's called OCMO modification or revocation of credential to practice. And we just say that generally the revocation should include, but they're not limited to those listed in that COG. And the reason why we want to put that in there is because we do believe at this time that the medical director could say, you know, I didn't like the way you looked at me, you're decredentialed. There's nothing that we would have recourse for that. And nobody is concerned about Dr. Escott. We're just thinking about a future medical director. And so we want it to be based on something. And so that we can at least say, like, hey, look, they didn't lie, they didn't fail to remediate, all these things that are listed in that. And so we could say, is it really fair that happened? And it doesn't even limit them to those things. It just says it can include, but it's not limited to. So that's the reason why we felt like it was important to include that in here. And it's similar, we included language that's similar to Article 14, which is drug testing. That just says that, you know, you can refer to the process for reasonable suspicion drug testing at the time that the contract is executed. So it's the same thing. So when this is amended, we want it to refer to that cog that's in place at the time. So section 5 talks about appeals. Again, all of this is already in policy and procedure. And all we're saying is that once a uniformed staff member, and this actually does bind our members as well, that once they receive notification that there's gonna be some action on their credentials, they have 3 days to appeal it. And they'll go through an MDCC, which is in policy and procedure. And in policies and procedure, it also says that the uniformed staff member can have access to the EPCR. We did broaden that a little bit to say their EPCR, computer aided dispatch data, and the DMO report. And so this language is mirrored after the protected rights of uniformed staff. And so all it says is that before the meeting of the appeal, they get access to these type of records. And it also says that a representative can be present in that meeting. The last thing is section 6. And we say that, you know, contract grievance can be pursued, and also that we don't want certain things that happen to stay with people forever. And so after 12 months, basically what happened, it can't be relied on in future actions with the medical director.
Even for those, the 12 months aspects only applies to more of the lesser of the extremes of like a clinical improvement plan or just written feedback. If it's something that goes beyond, we're not getting into that discretion of
So how many questions?
I think on this one, we'll have to take it back.
Yeah.
Kind of digest it and figure out what questions we have. On the last section, your intention was to not compare or take away any of the discretion of the medical.
The medical director has broad discretion because people are practicing under their license. So we understand and respect that broad discretion. We just want to make sure that there's, you know, the way that I told the team is we need to trust the process and not trust a person. And right now, that process, the way these go is we're trusting the person, not the process. And so if we can have a process where there is some transparency and expectations, then that will help, especially with the right to representation. That makes sure that we don't have instances where people's credentials are held modified, you know, for unnecessary delay or for any other thing, maybe a personal reason. It eliminates the opportunity for, I guess.
And we also want to be clear that we're not saying that, we understand that there are times where the medical director might temporarily suspend your credentials. So, you know, something happened, they want to temporarily suspend for a week or whatever. We are also not talking about them needing to go through that process for the temporary stuff, just like when chief puts somebody on ADL, we're not asking for, you know, them to have to go through the whole OPC process in order to put them on ADL. So we're just talking about any permanent change to their credential.
And on section 5 appeals, is the appeal process the statutory or what appeals process is that?
That appeals process is the appeals process as laid out in the policies and
Okay.
procedures.
Just want to check. I believe that's getting to. So it's
The one that's established in policies and procedures.
pretty much we took what was already in shape, codified aspects of it here. Without, because our intention is to not limit that discretion the inherent discretion that the medical director has, but at the same time, provide process transparency and gives employee ability to at least be brought against.
Any questions? Can I ask a question on, and it has to do with Article 12? I think Sarah may have already hit on this part, but on Article 12, you know, it looks like it could be simple enough, but there's just, you know, any little change on this whole transition can affect a lot of different moving parts. And one of the things that I think that we need to take into consideration, just for instance, of the discussion that we had on seniority and time and service and things like that, I think a lot of that has to do with also affects promotions and how the hiring process will affect promotions. I just wanted to see, do you have an anticipated proposal on promotions, or what do you anticipate on that so that we can work? Because I think we're all trying to figure out, we want to work off of one document, kind of one, I think that we've kind of talked about being how the department is envisioning this transition. I think, you know, on Article 12, a lot of the concepts are good and I think in line with, of course, I have to talk to my team, but I think that they're very workable. And so I just wanted to get just a feeling as to what you may, when you may, or if you're ready to present on anything on, not today, but when we may be looking at something on 13, because we're probably gonna have to look at those together.
She's flipping those numbers.
I'm sorry, 12 and 13.
Yeah.
Sorry, excuse me, I misspoke.
They knew.
Yeah. The public doesn't, so
Yeah.
13 is hiring and we're going backwards on 12 for the promotions.
We're pretty close on being able to present something on 12. But obviously, you know, and I do think that there's a lot that we want to add when it comes to PA school and all that other stuff. It's language that you've seen because we talked about it in subcommittee last time. And have had similar conversations, I think, about everything. For us, it's really just adding in, well, there are quite a few concepts, but a lot of it you've seen. And so I think we're pretty close, and potentially by next week, we should be able to show something, but also with the understanding that, you know, I don't know that we would call it an official offer because there's just so much. to it.
Right, and that's what we were thinking, we were gonna work on like 12 and 13 for the rest of the day, aside from what you proposed on your new article. And we meet Wednesday, right? So we were thinking by that time, and I think Monday is a holiday, so I was thinking probably by like Tuesday, we can touch base and one or the other of us can have like the document we work from. But both of us will have something closer on 12 so that we can have some productive discussions on Wednesday on, mostly on 12, because 13 is, we will have changes, but substantively, I think we're fairly close on, you know, 90% of it. So, but 12, because there's so much out there, I think we should both be working our own documents, but when we get to the table, I think we need to start from one document. And then if it's your document, then we integrate our thoughts in the different color, so that, because that can get crazy. And I know last time that particular article did get crazy. So I like how there's A, there's B, and then you've taken in 13, how you just kind of, and I think we should try to do the same if we can, but it's gonna take a lot of everybody going through line by line to make sure that we're touching on everything we want to, while still having the full document. Yeah, so.
Yeah, and I think y'all have been very good about, you know, like making sure that that what we're trying to do is being done in the contract. And I think we are the ones that are trying to push new ideas and different things. So you know, happy to try to take the first go at 12. But if y'all are prepared and it makes more sense for us to add on, then you know, we can kind of talk about that on Tuesday.
Yeah, I'm thinking yours will be the best document to work from, but if we already have our language, you know, to be able to cut and paste and integrate it, rather quickly, I think we can work that way.
And I think you're right, a lot of, I mean, Article 12 promotions is a lot to tackle. And I think a lot of the discussions at the beginning, although we may have some language, there's gonna be a lot of conceptual discussion. Because I think we need to pin down the concepts before we pin down the language. So I anticipate that's kind of how Article 12 is going to be discussed, that we're gonna be dealing with a lot of the concepts.
Yeah, and I think, and tell me if I'm on the same page as you and your team or not, I think we wanna try to do that all here if we can.
Yes.
Although it may lend itself to a subcommittee, I feel like there's a lot of frustration with people who weren't here on your team last time and trying to catch them up as to how certain decisions, because it was a lot.
Yeah.
So I think at least to start with, we will try to do it at the table. If it just gets overwhelming, we may then look at a subcommittee, but I think just for the purposes of people who are watching, that sort of thing, we'll try to do everything.
And so it sounds like, since we basically TA'd on most of the things, so it sounds like y'all might want to come back with, an understanding about Article 8, just about how we wanna move forward with that. And also maybe questions on, 13 and 17, or even an offer on 13, unless y'all wanna hold it until 12.
Let's caucus and figure out what we're gonna come back with. I think we should come back at least once, and then we can kind of see where we are. If we have a better concept on 8, and if we have anything to offer you outright on 13, or at least conceptually, if there's any differences where those are, and then so that we can address them during the afternoon and then on Wednesday. Okay.
All right. Thank you all very much.
one barbecue plate in case anybody wants it. It's all yours.
Never turn it down.
Yeah. You'll take it with. Just discuss.
I'm solo this week, I might be
You're like, I already got it.
You, Taurus.
We're live. Y'all ready?
Yes. Oh.
Good afternoon. We have prepared and provided for you tentative agreements as we discussed for Article 1, the preamble, Article 2, definitions, for definition 1 on agreement and definition 14 on uniform staff, Article 5 on the payroll deductions and union dues, and Article 3, the term of agreement. And I have added to each of those a footnote that indicated that the date, May 1st, 2024 is used throughout the tentative agreement, so used as a placeholder as we discussed. And I tried to, we're still following the legislative format that we had been doing. And so this on the electronic copy appears green, but for some reason our printer decided that it started off in blue and then went green. So these are supposed to be green. It was just a printer deal. And those have been executed by the city and we've provided them to you for. See. And we've already, you've given to us the executed copy of the ground rules, so we have those documents, correct? Okay. Next, on the Article 8 that has been presented by the union, we're taking a look at it and HR Article 8 that we proposed. Yeah,
Okay.
city, I'm sorry, the city presented. I misspoke. The Article 8 that the city presented, where we had some discussion on, we're looking at it and we're looking at the people that it affects. And so we're talking to HR and kind of doing a deeper dive into that to look at what that impacts. So we're gonna take a deeper dive on that and we'll have some, we'll come back with that. Okay. Article 12 on the hiring, where of course, I mean, Article 13, I wrote it down wrong. I keep getting
I
those
just
two
want to
mixed
call it
up.
Article 9, like I keep calling it. Every-
Article 13 hiring, we're going through that, and as we stated before, generally, we're, the concepts and the ideas and the goals are, look to be acceptable. We're still working on the, just the details and looking at what that does. We also want to make sure that we consider if Article 12, the promotions, when dealing with that, and so we're going to be working on that.
But let me be clear before that's misconstrued. In Article 13, we will have at least one change, so we're not totally in agreement on
Oh,
the
okay,
concepts,
right.
but we're very close.
We're very close. And we should be able to have a response to Article 13 at the next session. We're also looking at Article 12, the promotions. And what we were gonna propose is that we can probably have one ready as well. And we know that you have stated your concepts on Article 12, such as the PA school and things like that. I think that what we're gonna do, and I'll continue to discuss this with you so that we can do it in a way that is efficient and we're working off of one document, but we're gonna prepare one, and I'll talk to you about how maybe we could incorporate your concepts on it as a union's proposal, and we can work from there. So we're working on figuring that part out, but at least from the city side, we will have what we propose to be the changes to Article 12, prepared by the next session and ready to present. Anything I'm missing?
No, I mean, there's a chance that we may just have it done by Tuesday and send it to you and see if you want to incorporate yours, so it's one document. Just so there's not two completely separate, but it may be enough different that we want to keep it two separate documents, but I'll probably go ahead and send it on Tuesday so you can get a flavor for it and see kind of how you want to visually handle it so that it's presented. Sure.
And I think that's all that we have from our side.
Yeah.
For this session.
Only thing I noticed is that there is a typo on Article 23. It was the specific provisions for.
Oh, I didn't fix that. I'll fix that and resend it.
I'm just curious what's going on in that space.
It's justified, not.
I tried to fix it.
that. I did that and I couldn't fix it for the life of me. Did you try to
I
fix it
tried
as
to
well?
fix it and I even tried to retype it and it retyped the same way. So
I did too. I tried to change font. I tried to.
I'll fix the order and I'll see maybe if somebody else can do something, because apparently I'm not good with
You
formatting.
tried to like remove all the formatting.
Right.
Unexpected hurdle in negotiations.
Yeah, the ground rules were terrible.
We're done.
With the note on that as
Yeah,
supposed
other
to
than
be
that.
or instead of, we will correct that.
Yeah, other than that,
Do y'all have any questions on Article 17 or not?
I don't think we have any questions. We really need a chance to just sit down with some others, as you can imagine, and chat through that before we even.
And I just sent over, before we came in, a slew of documents that corrected Article 13 that just removed the duplicate, language. And then also, what's currently in policy and procedure as far as clerk board view goes, and then also the cog that we pulled that document from. So, you'll have a little bit more to see that, how closely we really hear some of that language, but really, you know, the context is from that policy and procedure and the drafting is from other language. Appreciate that.
Yeah, I think for the table, that's probably all we have today. I don't wanna keep our viewership. Yeah, I mean, we could continue to work on some things separately, but.
Right.
I think we're getting somewhere.
Yeah, absolutely. So these are the TAs and then I'll leave the one with the typo.
2012.
Okay, and we'll have it ready for next execution.
Okay, thanks all.
Very
Thanks a lot.
Okay.